Welcome to Introduction to Employment Law. I'm Kimberley Inniss-Peterson, and I am your human resource consultant. Today, we are going to walk through this webinar, one of 6 in a series. Let's ponder this quote for a moment by Peter Drucker. The successful person places more attention on doing the right thing rather than doing things right. And human resources is all about doing the right thing, especially when it comes to managing your workplace and the people who do the work for you. Hello, I'm Kimberly. I protect businesses from unnecessary risks and costly mistakes through human resource and business consulting outsourcing solutions. Well, what do I do exactly? Well, I solve your business problems before they happen. I help you fill gaps and mitigate risks with issues stemming from managing your employees. My services are professional, personalized for your needs, and protect you and your business from unnecessary risks and costly mistakes. Whether you're facing a current employee challenge, looking for advice before making a decision, or simply need a policy audit to make sure your bases are covered, I can give you peace of mind that your business is moving in the right direction. My backstory is that human resources is my second career after a workplace injury many years ago. I started off in nonprofit business, moved into more focused area of human resources, and I've been doing this for about 12 years. I'm very passionate about doing the right thing in the business, in the workplace, because I know it always leads to doing things right. I love empowering the people who do the work, and I know that people who are empowered are going to do a fantastic job and raise your business to the next level. I am a registered professional with a regulatory body, the Human Resource Professional Association, and I have a registration number. Feel free to go to the public register. You can look me up by searching me on that, using that number. You can see my background, my disciplinary history, how long I've been registered with HRPA. You can get more information about my business there as well. Because I'm a regulated professional, I have to follow a very strict code of ethics and best practices based on evidence of effectiveness. I engage in continuous professional education so that I can keep my registration number and stay current with all the changing landscape of employment law. In addition to being a professional, I'm also a wife and a mother. I'm an entrepreneur, and I coach junior human resource professionals in their career development. Today's webinar is just one in a series of 6. Today's Introduction to Employment Law. In the following webinars, we will discuss workplace policies and employee handbooks, then legally defensible human resource practices, followed by the employee life cycle, and then workplace culture. If you follow the whole series, you will develop a very robust human resource strategy and plan for your workplace. Maybe you don't need to follow or attend all the webinars, or you can just simply pick and choose which one that resonates with you and one that you need in your workplace. My approach to human resources is like building a pyramid where you want to have a good, strong, solid foundation in compliance with employment laws. Next, we focus on building your core strength, and that includes your human resource operations with things like workplace policies, the employee handbook, and defensible human resource practices. Once we have a good foundation and a good strong core, we move into more strategic human resources just to top things off. And that includes things like understanding and leveraging the employee life cycle and workplace culture. A legal disclaimer is that the information contained within this webinar is not legal advice. It's for information only. It's not intended to be legal advice, and certainly may not be applicable for your particular workplace situation. The information contained within this webinar is applicable to small businesses in Ontario, as well as non-unionized businesses within Ontario. Let's get started on our employment law journey. There are 5 basic employment laws that I decided would be the most relevant to small business owners like yourself: the Ontario Human Rights Code, Employment Standards Act, Occupational Health and Safety Act, Accessibility for Ontarians with Disabilities Act, and Pay Equity Act. There are more laws than these 5. However, these are the 5 that are most applicable to small business owners in Ontario that are non-unionized. The Ontario Human Rights Code guarantees equality before the law and prohibits discrimination in specific social areas such as housing or employment. Obviously, for today's webinar, we will only discuss the Human Rights Code as it applies to employment. As a small business owner, you are responsible for ensuring your workplace is free from discrimination. In order to do that, you have to understand where discrimination can be found. What's listed in this slide are the 12 protected grounds. Protected grounds means that these are areas where discrimination has been often identified, and the law prohibits discrimination in the workplace based on these 12 protected grounds: age, record of offense, ancestry, race and color, citizenship, ethnic origin, gender identity and gender expression, sex, including pregnancy and breastfeeding, sexual orientation, creed, disability, family status, including single status, and place of origin. As a business owner, you have to be aware that these are 12 protected grounds. Discrimination can occur in many different ways, and it can often be hidden, or what we call constructive discrimination, where discrimination exists by accident. What do you need to know as a small business owner about the Human Rights Code? The code states that every person has a right to equal treatment with respect to employment without discrimination or harassment. And you, as the business owner, have the responsibility to ensure that your business, your workplace, is free from discrimination and harassment, especially around the 12 protected grounds. The Supreme Court of Canada has made the Human Rights Code quasi-constitutional, which means that it is the top law. If for whatever situation, circumstance, that different employment laws contradict each other, the Human Rights Code is the prevailing law. That's the top law. If an employee feels that they are being discriminated against based on one of the 12 protected grounds, they can file a complaint with the Human Rights Tribunal, and it's the tribunal that decides if a complaint is based on discrimination. I would strongly encourage you to visit the Ontario Human Rights Code website to learn more about human rights and discrimination. In 2 upcoming webinars, I will discuss more on the Human Rights Code. Those webinars, the second one, or the first webinar, will be on workplace policies. The second webinar will be legally defensible human resource practices, where I will go into more depth on the Human Rights Code in both of those webinars. The Employment Standards Act, or ESA, sets the minimum requirements known as standards and are the rights of employees and the responsibilities of employers in the workplace in Ontario. The purpose of the ESA is to protect employees from receiving less than the minimum that is required. Think about the ESA as your workplace manual for managing your employees. As a business owner, what do you need to know about the ESA? The ESA, Employment Standards Act, sets out the rules of the workplace. So rules such as the hours of work, the minimum wage, termination notice and pay, public holidays, record keeping, job protected leaves of absences, vacation time and pay, and equal pay for equal work. As a business owner, you must know two things about the ESA: that all employees within 30 days of getting hired must receive an employment standards poster that outlines their rights as they are listed right here, as well a number to or contact information to the Ministry of Labor should they need to file a complaint against you, the business owner. If an employee does decide to file a complaint with the Ministry of Labor, they are free from reprisal from you, which means you cannot discipline or treat your employee poorly because they are exercising their right under the Employment Standards Act. The enforcement arm of the Employment Standards Act is the Ministry of Labor, and employees can file a complaint with them. If the complaint is taken seriously, the Ministry of Labor will send out an Employment Standards officer who will do an investigation. As mentioned in the last slide, you as the employer cannot discipline your employee for exercising their rights under the ESA. If you have an employment agreement with your employee that exceeds the minimums set out in the Employment Standards Act, such as in a contract, then it's the contract that becomes your governing law, which means that as long as the contract exceeds the minimum standards in the ESA, that is what we call a greater right or benefit. So the contract supersedes the ESA. Employees cannot give up their rights that they're entitled to under the ESA, and you as the employer cannot coerce or force an employee to do so. Not all occupations are covered under the ESA. Some employees do not fall under the Employment Standards Act. There's a lot of different ones. For example, emergency workers, such as paramedics, nurses, police officers, firefighters, none of them fall under the ESA. There are some seasonal occupations that don't fall under the ESA. Unionized employees also do not follow the ESA. And there are various others. If you are wondering if your business must follow the ESA, please visit the Employment Standards Act on the ontario.ca website and read more about occupations that are not covered by the Employment Standards Act. The Occupational Health and Safety Act protects workers from health and safety hazards on the job. It sets out duties for workplace parties and rights for workers. It establishes procedures for dealing with workplace hazards and provides enforcement of the law where compliance has not been achieved voluntarily. The Occupational Health and Safety Act is one piece of employment legislation that can bridge from employment law into criminal law. There are lots of cases where employers and supervisors have been fined quite heavily and or imprisoned for causing workplace hazards so terrible where people die. What do you need to know as under the Occupational Health and Safety Act? Employees have rights and obligations under this particular act. Their rights are the right to participate in Health and Safety Committee, the right to know about workplace hazards. They also have a right to refuse unsafe work. If an employee is exercising their rights under the Occupational Health and Safety Act, you as the employer cannot punish or discipline them in any way. employees are free from reprisal, just like in the Employment Standards Act. Employees also have obligations in the workplace under the Occupational Health and Safety Act. They must work in compliance with the Act. They must follow workplace safety policies and procedures. They must report unsafe conditions, and they must not circumvent safety devices or practices in the workplace. Employers have duties as well. You must have reasonable precautions for safety put in place. You must comply with compile health and safety reports. You have to maintain your equipment in good and safe working condition. You must train employees on health and safety, your policies and practices, and if they're working on any machines or any specific health and safety training, you must provide them. You also must comply with the Occupational Health and Safety Act. You have to read it and understand it. Some employers will opt to hire their own health and safety officer or have a position just for health and safety. They may contract out for that, or they may contact a third-party provider. As an employer, you must have health and safety policies that are compliant with the Act, compliant with all laws, and they are updated regularly. You must also post a copy of the Occupational Health and Safety poster and any relevant material. And if you have a joint health and safety committee in your workplace, then you must cooperate with the findings of that committee. Now, not all workplaces are required to have a health and safety committee. It depends on the size of your workplace or the number of employees, as well as the industry that you operate within. This chart here gives more information about the requirements in the workplace. If you have between 1 and 5 employees, then you are not required to have a joint health and safety committee. If you have between 6 and 19, you are required to have at least one health and safety rep. If you have between 20 and 49, you're required to have a joint health and safety committee with some rules. And then if you have more than 50 employees, again, you have to have a joint health and safety committee, and there are rules around who should be on that committee. For more information about the Occupational Health and Safety Act, then I would encourage you to visit ontario.ca with under the Occupational Health and Safety Act. The website is on the slide, and you can find out more information. The Workplace Internal Responsibility System, or the IRS, which is the philosophy based on the Occupational Health and Safety Act, is actually based on the IRS philosophy, which means both employers and employees take initiative on the health and safety issues and work together to solve problems and make improvements. So employees and employers, the workers and the business owner, both have responsibilities to ensure the workplace is safe. It includes every worker, supervisor, employer, and every single workplace in Ontario, with some exceptions. There's always a few exceptions to these workplace rules, right? So for the Occupational Health and Safety Act, it does not cover private residences or on the land that connects the workplace or under federal jurisdiction. So federal jurisdiction would include things like any federally regulated industries such as telecommunications, airlines, banks, major transportation like railways, ferries, a few other industries like that. The enforcement arm of the Occupational Health and Safety Act is the Ministry of Labor, and they will send out inspectors if there's any violations. Employees can contact the Ministry of Labor and say, this place is unsafe, I need an investigator or inspector to come out before I return to work, and the Ministry of Labor will send out an inspector or investigator who will analyze the situation, talk to your joint health and safety committee rep or whoever you have, depending on the size of your business, and they will determine if your workplace is safe or dangerous. WSIB, I'm sure we've all heard of that. Not every industry will pay in to WSIB, but it is an income replacement system. And the WSIA, the Workplace Safety and Insurance Act, governs the WSIB. If you're unsure if your business should be covered by WSIB, then contact them, the WSIB folks, and speak to a representative there. If your business is non-compliant with the Occupational Health and Safety Act as determined by an inspector, you may face a massive penalty and or jail time. As a business owner, you might want to spend some additional time, money, and energy on making sure your workplace is compliant with this law. Accessibility for Ontarians with Disabilities Act, or AODA, is a law that sets out a process for developing, implementing, and enforcing accessibility standards. The Government of Ontario has set a very lofty goal to have eliminated barriers to people in Ontario by 2025, and that is sneaking up on us pretty darn quickly. All businesses must follow the AODA. What do you need to know? AODA is, for your business, you must create accessibility policies and or a statement, depending on the size of your business. You must train your staff on these policies. You must document your policies and the training that you give your staff, and follow, of course, any additional accessibility laws. You must have accessible employment practices, accessible customer service, and accessible information. Depending on the size and nature of your business, you will have to file accessibility compliance reports. There's so much you need to do, isn't there? Accessibility laws and standards reduce and remove barriers and make Ontario inclusive for everyone. This is the most common sense you can think, right? Everybody should have the ability to assess the workplace, either as a customer or as an employee. There are reporting requirements and deadlines, and it does depend on the type and size of your business. If you have less than 20 employees, all you need is your policy, your accessibility policy. You have to train your employees on it. You must have accessible customer service, accessible employment practices, and accessible information. So accessible customer service can be, you can find training modules just about anywhere. If you do an AODA customer service training search on Google, you'll find all kinds of wonderful resources. This is the information that your employees need to be aware of if they're going to be dealing with customers or clients, or if they have to come into the workplace, into your business. Employment practices, also you want to be aware of accessibility for candidates coming in to do interviews, as well as current employees. You might want to read the Ontario Human Rights Code again. Disability is a protected area, and you must be able to have provisions in place for anybody with a disability to access employment. Disabilities are not always physical. They can be psychological, mental, and you're going to want to be aware of that. You have to have employment practices that are inclusive for everyone. If you have between 20 and 40 employees, you have to have the policy. You have to train your employees. You have to have accessible customer service, accessible employment practices, and accessible information. Plus, you have to file an accessibility compliance report every 3 years. If you have more than 49 employees, you have to have the policy. You have to train your employees. You have to have accessible customer service, accessible employment practices, and accessible information. Plus, you have to file a compliance report every 3 years, plus a multi-year plan, plus your website has to be accessible. If you have no employees, you're a sole entrepreneur like myself, then you're totally exempt. More information can be found on this website on this slide. You can also go to aoda.ca for more information. The Pay Equity Act is a very interesting act. So this is one where if you have more than 10 employees, you have to achieve pay equity by eliminating sex-based wage discrimination. What is that? Well, we're going to find out. What do you need to know about the Pay Equity Act? If you have more than 10 employees, you have to ensure that your female-dominated job classes have the same rate of pay as your male-dominated job classes. Yes, it is that easy. Well, how do you do that? Well, number one, you identify which job classes you have. You have to determine if your employees are female-dominated, male-dominated, or neutral. Then, once you've identified those, you assign a value based on skill, effort, responsibility, and working conditions. You then compare all your female job classes to your male job classes to ensure equity, and then you adjust wages accordingly. You cannot adjust wages down, you can only adjust wages up. It's not the same as equal pay for equal work in the Employment Standards Act. If you recall on that slide, one of the ways that you manage your employees is to ensure that they have equal pay for equal work. That is when two people do a job, do the same job, they must get paid the same. Equal pay for equal work. It has nothing to do with gender. It has nothing to do with job classes. You can have two servers in a restaurant, one male, one female. They must get paid the same because their job is server. The pay equity, however, is to reduce sex-based wage discrimination, which means that if you have male-dominated job classes that are paid higher, even though in comparable female job classes, their wages are lower. The idea is to raise the wages of the comparable female job classes. And it is compared within the same organization. So you don't worry about Joe's business across the street. You just have to worry about pay equity within your own business and within your own ranks. A female job class is one in at least 60% of the positions are held by women. And the purpose is to correct systemic discrimination in compensation for female job classes only. Therefore, it does not apply to male or gender-neutral job classes. For more information on the pay equity, you can visit payequity.gov.on.ca. You can learn more about how to adjust wages as well. Now, some businesses will hire a consultant to come and just review wages and make sure that you and your wages are in compliance with pay equity. Or you can do a little bit of research on your own and figure it out. Or you can hire me and I can go through those things with you and make recommendations. Okay, so let's see if you've been paying attention. I'm going to do this little quiz with you. And the quiz is called, Where Do You Turn? And so you have to answer the questions. Where would you turn to get more information based on these scenarios? So are you ready? Get a pencil and let's jot down your score as we go through them. Let's see who's going to win. So let's talk a little bit about family responsibility leave. You have an employee who returns back to work after a family responsibility leave, which is a job protected leave of absence. Your employee is upset that his paycheck is less than he normally receives, and he's not happy about it. He's telling you that his job protected leave was supposed to be a paid leave. And you're scratching your head and you're thinking, did I make a wrong move here? Where do I turn for more information? What are my rights and obligations as an employer? What are my obligations as an employer? And what are the rights of my employee? Where do you turn to get more information? Well, you can call me and I can give you the answer. Or you can go to the Employment Standards Act. The ESA is your workplace management manual. It includes information about job protected leaves. Family responsibility leave is one of those. If you don't have a contract in place that explicitly says that your employees will be paid on certain leaves, then you have to fall back on the Employment Standards Act. Currently there are no paid job protected leaves under the Employment Standards Act. Maternity and parental leave are not paid leaves. However, employees can file with the federal government for income replacement. That's not the same as an employer paying for the leave. Some employers will top up maternity and parental leave payments, but there's no obligation to do so. There are no paid job protected leaves under the Employment Standards Act, unless you decide as an employer to pay your employee. That is something that is completely up to the employer to do. Let's move on. So if you answered ESA, you get 1 point. Let's move on to the next one. Employee notice. Your business is slow and it's very likely that you will be laying off employees. And you read somewhere that you have to give so many weeks notice. But how much do you give? How much time do you give? What are your obligations as the employer? Where would you turn for more information on what your obligations are? If you answer the Employment Standards Act, you are correct. Give yourself a point. Remember, the ESA is your workplace management manual, and it gives you information about things like this. So employee notice is really interesting, and you're going to want to pay careful attention when you go and you read the Employment Standards Act, because there's lots of different rules around different situations. The most common, however, is that every employee is entitled to 1 week's notice for every year of employment, up to a maximum of 8. That's the most general. Now, there are always exceptions to the rules. And those exceptions are also laid out in the Employment Standards Act. But for the most part, employees are entitled to 1 week's notice per year worked, up to a maximum of 8 weeks. So if your employee worked for you for 12 years, they get 8 weeks notice. If your employee worked for you for 1 year, 3 months, they get 1 week's notice. If your employee worked for you 1 year, 6 months, how much notice do you give? There's a formula in the Employment Standards Act that you would have to follow. So give yourself 1 point if you said the Employment Standards Act is where you would go to get more information about this particular situation. Moving on, now we have an interview. A candidate with great skills, education, the whole 9 yards comes in, does an interview. They happen to mention that they cannot drive due to a disability. And you decide after hearing that you're not going to hire them. Can you do that? What is your right? What is your obligation? Where would you turn to get more information? Give yourself 1 point if you said Ontario Human Rights Code, because if you recall, one of the 12 protected grounds is disability. If you have somebody who comes in and does an interview for a position that does not require driving and does not necessarily require perfect eyesight to do, and is one, even if eyesight is an important qualification, that you can accommodate somebody who doesn't have perfect eyesight. You have to give this person, if they qualify for the job, you have to give them a job, whether or not they are disabled. When you're doing an interview with someone and they reveal that they have a disability and you eliminate them completely right off the bat without considering anything else about them, that's discrimination. If you are interviewing someone for a bus driver position and they come in and they say they have low vision and it's a disability, that's completely different. The ability to see well, if you're going to drive vehicles where, safety is is a top concern, obviously, then you have every right to turn someone away if they fail that particular qualification. If you have a receptionist, for example, who comes in, she meets the qualifications, she does an excellent job at the interview, however, she's disabled. That is a completely different story. The disability has no bearing on her ability to do the work as a receptionist. It is up to you as the employer, however, to accommodate in a situation like that, if that's the case. Because under the Human Rights Code, everybody has a right to engage in meaningful employment. And you have the duty to accommodate and remove barriers so that people can access employment. So give yourself 1 point. If you said the Ontario Human Rights Code is where you would turn for more information on a situation like that. Next situation, a worker refusal. An employee refuses to work due to a machine malfunction. That means you're not going to meet your orders for the week and you're not happy about it. What are you going to do? Where do you turn for more information to determine if this situation, what you're going to do in this case? Give yourself a point if you said the Occupational Health and Safety Act. Employees have a right to refuse work, unsafe work. So you'll remember on that slide when we talked about the Occupational Health and Safety Act, one of the rights of the employees is the right to refuse unsafe work. One of your obligations as a business owner is to ensure that the workplace is safe. So it's up to you to investigate the reason why this employee is refusing to work, why he's saying it's unsafe to do so. Next situation, where would you turn to get more information? This one in particular is around harassment. An employee reveals another has been harassing her through Facebook. Since it's not happening during work, it's not your problem, but now she refuses to work with the other employee. Now this one's tricky, isn't it? It's outside work for the most part. Do you have to do anything as the employer? Where are you going to turn to get more information about your obligation as the employer? Give yourself a point if you said Occupational Health and Safety Act. Under the Occupational Health and Safety Act, there is a whole section on harassment and violence in the workplace. And that's where you're going to find the information you need around a situation like this. So in fact, you are responsible, even if this is happening outside of work. You, as the business owner, are responsible for ensuring your employees are safe at work. Next situation, cutting the budget. Financial difficulties. You have some new folks joining you, in particular, new administrative assistants. They earn less than the maintenance crew that's coming on. So that's how you're going to save money. You're going to pay your admin assistants less than your maintenance crew. Is it allowed? Where would you turn to get more information about that? You scratch your noodle around about this one, right? So give yourself a point if you said Pay Equity Act. So the Pay Equity Act sets out to reduce sex-based wage discrimination, which is clearly the case here. Administrative assistants are predominantly female, maintenance crew predominantly male. So you need to do a pay equity analysis here. You cannot just offer lower wages to female job classes to save money. Next situation, I promise this is the last slide on this, but I hope you're getting a good score so far. You're scoring 1 point for each one already. You'd have 6 points. Next situation, the next scenario is pool installation. Your company installs and maintains swimming pools. Your business only runs from May to October. Your employees are complaining because you haven't been paying them overtime or holiday pay, and they're just, they're working weekends and 12-hour days, and they are complaining, and they say, we know our rights. You're not allowed to do this to us. Well, are they right? Where would you turn for more information on how to manage your employees around this sort of thing? Give yourself a point if you said the Employment Standards Act. Remember, the Employment Standards Act is your workplace manual, and you want to understand what your obligations are as the business owner. Interestingly enough, however, pool installation and maintenance employees are not covered under the Employment Standards Act. So you don't have to pay them overtime. There's no limits to the number of hours they work in a week, unlike most other employees that are covered by the ESA. You can do pretty much whatever you want with your employees. The Employment Standards Act does not apply. It's a very strange situation, but that is in the Employment Standards Act. Now, that doesn't mean you can treat your employees with total disregard. Of course, you still want to treat them well because they are people. And you don't want to have people quit on you in the middle of the summer when it's busy pool maintenance and installation time. You still want to treat people with respect and pay them well and make sure that they have the proper work-life balance. The Employment Standards Act is meant to help employees and employers find that balance, but absolutely not everybody is covered under the ESA. Next scenario, give yourself a point if you know the answer. Where do you turn for information? Next one is drinking on the job. You have an employee who's always been a very fantastic, dependable employee. However, all of a sudden you've noticed that their work quality is declining. You confront the employee and he breaks down and says, I'm an alcoholic. I was just diagnosed and I'm having a hard time here maintaining my work and my family and being an alcoholic. Well, you don't like the sounds of this, so you decide you're going to fire him. But wait a second, hold on. Before you do that, what are your obligations and what are your employees' rights? Where would you turn for more information on this? This one's a tricky one. In fact, if you get the answer, give yourself 2 points. You want to turn to the Occupational Health and Safety Act and the Employment Standards Act. There's 2 things here that you need to consult. The Ontario Human Rights Code lists alcoholism as a disability. So if your employee has been determined to have alcoholism, it's a disability. So now we have to tread carefully after this point. The Occupational Health and Safety Act says that you can't have people in the workplace that is unsafe for or causes workplace hazards, and you have a duty to keep all your employees safe. The Employment Standards Act also talks about how to terminate an employee if that's what you need to do. So it's a very difficult situation. I would caution that if this truly is a situation that you're ever confronted with, to speak to a human resource professional or a lawyer to get more information on how to handle this, because it is a very, very tricky situation. Next situation, servers. Remember to give yourself 1 point if you get the answer to this. You reward your female servers with a bonus because they generate more alcohol sales than the male servers do. And your male server says, I'm not happy with this. This is not right. This is discrimination. I demand, I want to get paid more. I demand equal treatment. Where would you turn for more information on this? If you said Pay Equity Act, you'd be wrong. So Pay Equity Act, if you recall, that is to eliminate sex-based wage discrimination for female job classes. It doesn't apply if it's gender neutral or a male job class. For this situation, you would turn to the Employment Standards Act under Equal Pay for Equal Work. Here we have a case where we have 2 servers who deserve to earn the same amount of money. If you have a bonus structure in place, it has to be one that males and females can access equally. It cannot be only females or only males. Equal pay for equal work under the Employment Standards Act is where you would turn to get more information about a scenario like this one. So that concludes an introduction to employment law. There was a lot of information shared with you today in this webinar. If you have if you want more information or if you have any questions, please feel free to reach out to me. I would be happy to explore your particular workplace situation. I can be reached at kim@kimhrconsultant.com. You can visit my website at kimhrconsultant.com, or you can send me a text or give me a call on my cell, 226-930-1999. I can be reached pretty much anytime during the day, Monday to Friday. However, I am also very busy, so please feel free to leave me a message. And sometimes you do have to wait a day or 2 to get a response to email. I have consultation packages available if you would like to explore more about working together as your human resource consultant. And I'd be happy to explore that with you. Hopefully you'll tune in to my next webinar, but until then, I say thank you so much for joining me, and I look forward to hearing from you shortly.